let's have some recap. We have discussed the objectives of the Act. Even every spokesperson has discussed about the objectives of this BSA. And as per the language of the Act, these are the of the Act. It provides that the evidence includes any information given electronically. Emphasis has been given this electronic evidence, forensic evidence, and the medical evidence under the now new Act. Second, it provides for admissibility of electronic or digital record as evidence as paper records. Now, you have also read the definition of this primary evidence and the secondary evidence. Now, the electronic record, or we can say the electronic evidence, has been treated as a document under the BSA, under the this amended provision. Earlier, there were three types of main evidences. One is oral evidence, one is documentary evidence, and third was the electronic evidence, which was given as a separate type of evidence. But now, the definition of the document has been amended, and this electronic record is now to be treated as a normal document as per the provisions of, we can say, Indian Evidence Act now in the BSA. The third is, it seeks to expand the scope of secondary evidence to include copies made from original by mechanical process, copies made from or compared with the original counterparts of documents as against the parties who did not execute them, and oral accounts of the contents of a document given by some person who has himself seen it and giving matching hash value of the original record will be admissible as proof of evidence in the form of more precise and uniform rules of practice of courts in dealing with facts and circumstances of the case by means of evidence. We had discussed this case also in that day, and then the definition portion, we have discussed the definition of court and also regarding the applicability of this Evidence Act. Earlier, this act was applicable to the court-martials, but Army, Air Force and Navy acts were excluded, meaning thereby the earlier Evidence Act was not applicable to those disciplinary rules. But now, BSA is applicable to all the court-martials. Then next we discussed the evidence, the definition of evidence and the incorporation of word this digital record. Then the definition of document, otherwise recorded, any other means including electronic and digital record. Then the illustration was also included. Then we also touched the definition under BNSS, that is the audio video electronic means. Then the electronic communication. Then the words which are not defined in BSA, then the support can be taken from the IT Act, BNSS, then BNS also. Then we had discussed what are the sources of EMs like digital cameras, video cameras, cell phones, computer laptops, mobile devices, file storage, wearables, automated license plate readers, in-car cameras, board cameras, drones, clothes, CCTVs, interview recording room systems. Then we discussed the daily documents or the other evidence confronted in the courts like FIR, DDR, recoveries, seizure memos, expert reports, medical evidence. Then the case diary, site plan, Panchnama regarding case diary. We also discussed that the provision has been made in BNSS regarding the maintaining of the diary as well as the forwarding of the diary along with the videography conducted during the search and seizure procedures. Then the rule of evidence in civil proceedings, it is proved by preponderance of probabilities. In criminal, it is beyond reasonable doubt. Then the principles of evidence, that is, it must be confined to the matter in issue. Hearsay evidence has no value. Best evidence rule must be followed. That is old in section 60, 62 under section 90 of Evidence Act. Supported by these facts, judicially noticeable need not to be proved. That is 51 under the new BSA, and old is section 56. But one clause it has been added that the court can take into account the extraterritorial laws into consideration, that is regarding those also. Then facts admitted need not to be proved. Then now we are even touching this rules of admissibility in evidence, because this is our topic. Then it contains first of all relevancy of fact. We are clear about it that if the fact is relevant, only then it would lead to the admission regarding that fact. And reversely we can say, if it is an admitted fact, it must be a relevant fact. But every relevant fact is not a admitted fact. Then it is contained in old section 5 to section 55, but now it is from section 3 to section 50. We had already touched section 3, which is parallel to section 6 of Indian Evidence Act regarding rule of justice, wherein it has been a new word has been included, relevant fact. Earlier it was only pertaining to the fact in issue, but now the relevant fact has also been included. That is, the scope of this section 3, or we can say section 6, has been expanded now. Then the next was the section 8, where some words were changed, that is ravished, rape. Ravished has been replaced by rape. And apart from that, there was no major change. Slight change was in the illustration in the definition of fact, that is, the reputation of a person is not now is not a fact. Then oral evidence was contained in section 59 and 60, but now it is 54 to 55. We'll discuss in detail in the later portion. Then documentary evidence, earlier it was 61 to 90, but now 56 to 92. That is, the document must be proved by primary evidence. That is the original document itself. Otherwise, the secondary evidence of the document can also be led. But if there is a presence of, we can say, documentary evidence as well as oral evidence, then the documentary evidence would prevail over the oral evidence. It is also provided in section 1991 of the old Indian Evidence Act. Then hearsay rule, which is the information received from others, that is, one cannot substantiate, it is generally inadmissible. But there are certain exceptions. We had already discussed regarding dying declaration, admissions, confessions, and the statements made. Then the admissions and confessions, these are contained from section 15 to section 25. We had already discussed that one word in the confession portion has been added, and under section 13, one explanation is added, which is pertaining to the joint trial of the accused. Then there is also a slight change in the definition of this expert evidence. In fact, we have already discussed. That is a confession made by one person against the other person. We have already discussed that explanation. Section 183, earlier it was section 164, that if a person making the statement is temporarily or permanently, mentally or physically disabled, the statement made by the person with the assistance of an interpreter or a special educator videograph. Then we have discussed this digital records contained in the official gazettes pertaining to state government notifications, central government notifications. Those are the relevant facts. Similarly, the law statute books, digital and electronic form is also a relevant fact. Then next is section 39, opinion of experts. Then opinion of experts in this section, this one word has been added. Earlier it was when the court has to form an opinion upon a point of foreign law or a science of art. This word has been added now, foreign law, science or art or any other field. Now the scope of this definition has been expanded. It is not only pertaining to the foreign law, science, art, because now the electronic evidence has been used and even the scope has been kept in the definitions that with the changing scenario, if there is any requirement that can also be added, the benefit of this definition can be taken in the longer run also. Then there is also this provision provides when in a proceeding the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital form, the opinion of the examiner of the electronic evidence referred to in section 79. Now the word has been used as examiner of electronic evidence in section 79 of IT Act 2000 is a relevant fact. And the examiner shall be the expert as per the definition, but it has to be notified to the government. Now the question will arise, who will be the expert? And since the 5 days we are discussing that the certificate is to be given by the party as well as by the expert. Now the question still remains, who is the expert? Now I am posing this question to the house, who is the expert? Section says, person this section provides central government to notify examiners of electronic evidence. The central government may further any department, body or agency of the central government or a state government as an examiner of electronic. For the purpose of this section, electronic form evidence means any information of probative value that is either stored or transmitted in electronic form and includes computer evidence, digital audio, digital video, cell phones, digital fax machines. Till date, I think there is no notification. Okay, who will be the expert?
What court is not binding to opinion of
Court?
the expert, not binding to accept the opinion of the expert.
Sir, please sit down. Please sit down.
Several judgments decided by the Honorable Apex Court that expert opinion is only opinion.
Only opinion. Very right. The courts are the expert of the expert.
But court is not binding. The court is a discretionary power.
No,
Whether
that is
accept the opinion of the expert or not.
That is right. That is only the opinion of the expert. Very right. But as per the requirement, now in section 63, earlier it was 65B, the certificate is required. Certificate of expert is required.
Then certificate is accepted by the court.
Two things. But opinion is relevant. Yes, yes. The opinion of examiner is expert.
If the certificate has been issued by the expert, then what will be?
So this question is still debatable. List. Medical evidence. I have already said number of times that medical evidence, forensic evidence, electronic evidence. Now the words finger impressions, voice samples is added in this definition, and the scope of this definition pertaining to section 53 has already been discussed by our Honorable High Court in a judgment Diwan Singh Ram Singh versus State of Haryana. This case was pertaining to the POCSO Act, and in this case the accused was convicted, and in the appeal he had taken the plea that I was not subjected to medical examination, and he had tried to take the benefit of that clause. That is section 53 and 53 of the Criminal Procedure Code. And in that case, the Honorable High Court formulated three questions: whether the direction given to the accused for submitting himself for blood samples is violative of Article 23 of the Constitution of India, number one, and whether the investigating agency is bound to follow the provisions of Section 53A of the CRPC. Third one, whether the accused can refuse to give the blood samples for DNA profiling, etc. Then, after discussing all the previous judgments from Gautam Kundu till and the Constitutional Bench of Honorable Supreme Court, and the distinction has been drawn between the physical evidence and the testimonial. And it was held that if it is the collection of blood samples is only pertaining to the physical evidence, and it was answered by our Honorable High Court in a revision bench that directing an accused to give blood sample for DNA profiling would not amount to violation of Article 23 of the Constitution of India. And the investigation agency is also bound to strictly follow the provisions of Section 53A of the CRPC. And third, the refusal of the accused to give blood sample for DNA profiling under Section 53 of CRPC would entail adverse inference on the last date. And the direction was also given, if the accused refuses to give the samples, then the application must be made to the area magistrate for seeking the direction of the court. I also referred this Act 2022, which prescribes the definition of measurement. The scope of this definition was also extended. Now, this iris and retina scan, photograph, physical, biological samples, their analysis, behavioral attributes, that is for psychological test of the accused, including signatures, handwriting, or any other examination, it is left open. Any type of examination referred to in Section 53 or Section 53 of the Code of CRPC. Now it is open to the police to make any application for subjecting the accused to any test. But there is one clause which prescribes the punishment. We can say the action can be initiated under Section 186 of Indian Penal Code. The question was raised that this provision has not been amended yet. But if we apply the provisions of BSA or BNSS, then the question would arise whether it is in contradiction of the provisions incorporated in the new act. The answer would be no. It is in consonance because it talks about section 86 of Indian Penal Code. So where there is a question of contradiction, or even it is a coercive method. I am again repeating. Then next was section 330 of BNSS. Now it says, whenever any document is produced in the court by any party, maybe by the prosecution, maybe by the accused, then the copy of the same is to be supplied to the other party. Suppose prosecution files one document or with application. Then the document is given to the accused with a 30 days time with the option either to admit or to deny it. Now it is just like a civil court procedure. As for the remission and denial of documents as contained in order 12 of the CC. Then provided that the court may in its discretion relax the time limit with reasons to be recorded in writing. Provided further that if assumingly it is the report is disputed by any of the parties to the trial. Then the list of documents, but still the list of documents shall be in such form as the state government may by rules provide. Where the genuineness of any document is not disputed, such document may be read in evidence in any inquiry, trial or other proceedings under this Sanhita without proof of the signatures of the person by whom it purports to be signed. Further, provided that the court may in its discretion require such signature to be proved if these are disputed. Then next is section 336 of evidence, which is pertaining to the evidence of public servants, experts, officers in certain cases. Now, if any police officer or any public servant expert is transferred, suppose, from his posting, then his successor can be called for evidence. This section option with the accused to challenge that person has not come present in the court. He can only challenge his report, and only for that purpose the examination of that person, that means successor, is to be conducted. Provided further that the deposition of such successor public servant appears to be very unreasonable. It would be prejudicial to the rights of the accused. So I think law will be developed regarding this section also. Yes. Police officer. Yes. Interpretation would come. It is only pertaining to some extent. Not in general. Interpretation would come. It is only confined to those areas. See. So the intent of this section, देखो evidence of public servants, experts, police officers in certain cases. In certain cases. Please kindly read the language. Is there any documents or reports prepared by a public servant? Document, whether this challan report can be considered as a document. Any document. Challan is not a report.
Challan is not.
Whether it is a document, it is a document. See, where any document prepared by a public servant, scientific expert or medical officer is purported to be used as evidence.
You will prove that that was investigated or looked into by the earlier IU. So it has to be proved because that IU has to be called.
I am also supporting your point. The law is yet to be developed. The law is yet to be developed.
Thank you, sir.
Yes. Challan is not an evidence. Challan is yes.
Challan is not evidence.
Very right. That's why I was asking that challan is a document. I was coming to the next line also. A report prepared by public servant, scientific expert or medical officer, which is purported to be used as evidence. Challan itself is not an evidence.
Sir, excuse me, sir. Sir, under BSA, what is the relevant section as mentioned in this 336 BNSS regarding private witnesses? This 336 of BNSS. In civil cases.
336.
Yes, this is under criminal cases. And what about the civil cases in civil law? BSA.
336 is pertaining to BNSS.
Yes. Equivalent section under BSA, which is that section.
In civil cases.
In civil cases regarding
Civil
private.
cases we are